Welcome back to Open Line, everyone. Tim Takacs is with us answering your calls about wills, estate planning, benefits, how to care for an elderly loved one. Several calls. Let's go to Taylor. Hello, Taylor.
Good evening, gentlemen.
Good evening.
Tim, I have a question on inheriting an IRA account from someone who's deceased.
Okay.
What is the time frame that one has to make a decision? What decisions does the holder of the IRA give you, and the time frame that you have to make a decision, if that's clear enough?
I think so, and let me just sort of set the stage here. Is people, there are a lot of people out there that have retirement plans, IRAs, individual retirement accounts, and most people, if you're married, you name your spouse, and your spouse hopefully names you, as the primary beneficiary. And so, like for instance, I pass away, and my wife is the primary beneficiary, and then she gets it. She now is the owner. And she has to start taking it out when she reaches age 70 and a half. And that's what most people think of. Okay, I've got an IRA or a retirement plan, and I have to start taking required minimum distributions when I reach age 70 and a half. That's the law. Okay, so Taylor says, okay, I've inherited an IRA. Now my question, or maybe he's inherited an IRA, my question to him would be is did he inherit it from his spouse? If he inherited it from his spouse, he would have to start taking it out if he had already reached age 70 and a half. Or if he hasn't, he can wait until he's 70 and a half when he has to start taking it out. But let's say he inherited this IRA from his father. And let's say Taylor is 62. Well, Taylor has to start taking his IRA out immediately based upon his current life expectancy. And a lot of people don't realize that. They say, well, I thought I could wait until I was 70 and a half. I'd say, no, but if you inherit an IRA from anybody other than your spouse.
Okay.
So when he's asked, well, what is he, what decisions does he have to make? Probably the only decision that he would make would be does he want to inherit it at all? And that means literally, it means is like, we've talked about that before, I think, is that no one can force you to inherit something that you don't want.
Now, why wouldn't you want it?
Maybe because you're in a high tax bracket. Maybe you have all the money that you need or want. Maybe that if you choose to what's called disclaim, you say, look, I don't want this $100,000 IRA because I'm going to have to start paying taxes on it right away. I'll disclaim and let the next person behind me get it. That's so maybe it's a younger person, maybe someone who is, who maybe needs it more than you do or whatever.
In that case, you're basically putting it putting it aside and letting it go to your child.
Maybe a child or another family, whoever the individual. Maybe you were the primary beneficiary, and maybe your child or somebody else is the secondary or contingent beneficiary. So if you choose not to take it, it automatically goes to that other person, that contingent beneficiary. And then they would be subject to the same rules. They have to start taking it out based upon their life expectancy. But there may be a lot of reasons why that would be a good idea for somebody to do. But that's the kind of thing where I would suggest to Taylor is that the decision that he really has to make is that does he really want to take it or not. But if he's already taken it, if he's already accepted getting the money from it, then it's really kind of too late for him. Mm-hmm. He's got 9 months from date of death in order to decide whether or not he wants to take that asset. Mm-hmm. That's
it's also
the rule.
A big difference about whether it's your wife or whether it's someone else.
Exactly. Yeah.
Okay. All right, Taylor, does that answer your question?
Yes, it does. Thank you very much.
You bet. All right, let's go to Mary. Hello, Mary.
Hello.
Hi, what's on your mind?
My father lives in another state, and I'm not sure if the laws here in Tennessee apply there as well. But my question is, up until July 8th, my father was completely capable of doing all his own finance, and he was even driving. And on July 8th, he had a stroke. 9 years ago, when my mother passed, he named my brother as attorney-in-fact and me as an executor, and there are 2 other siblings. But what can I do as the executor of the estate to ensure his intentions are met, and what is my role now that he is unable to conduct his business?
Are you worried about your siblings, your brother?
Yes.
Okay.
Okay.
So she's an attorney. No,
Yeah,
she's the executor.
She's the executor.
And then you have an attorney in fact.
Her brother is attorney in fact, and so for people who maybe are not familiar with the lingo here, an attorney in fact, it's often where people think about it, well, I'm power of attorney for my mom. You know, her brother is power of attorney for her father, you know, for Mary's father. So she's going, okay, I'm not sure I like this. I'm the executor of, you know, for my dad, but being an executor right now doesn't mean anything for Mary because nobody's dead yet.
It's only
that her father has named her to take charge of his estate at his death. That's the only time when, you know, that's the extent of whatever authority that she has, and that authority is not here yet.
The attorney in fact, that plays a bigger role in his life.
Oh yeah, absolutely, because that deals with living folks. You know, so her brother is attorney in fact for father, and I'm guessing that what Mary is concerned about is, well, if her father is not able to make decisions for himself, then that makes brother the first in line to do those things. Now, on the one hand, maybe that there's some concern there for Mary about, well, what's my brother going to do? Well, there's nothing like communication that might help this situation if it's going to go south here, or maybe it's already gone south. But at the same time, merely because or just because brother is power of attorney for dad doesn't give brother license to do whatever he wants.
She may be worried, he's going to siphon off whatever he has left.
Yeah, but the important thing, I think, for her to remember is that her brother has what's called a fiduciary obligation to act in the best interest, of her father. So, he has an obligation to act in his father's, his best interest. And if he doesn't, then she may be winding up chasing him down and suing him in the long run if that's what needs to happen. But for now, it's one of those things there. Okay, do they need to have a conversation?
Oh, they do.
Yeah, they need to have a conversation. Also, what we don't know, and maybe
she's still here.
Maybe we can. If we've got a little bit of time here, maybe we can ask Mary if, is her father, does he have capacity? Can he make decisions for himself?
Do you hear that, Mary?
The stroke took his memory.
Okay.
He has no knowledge of the finances that he has set aside, nor I was his nurse for the first month. I was not his daughter.
Yeah.
He did remember me as time went on, so he knows that he has children. But we wanted to keep him in his home with caregiving and just to make sure that his assets are protected.
Yeah. Yeah, and that's the sort of thing where, when I start thinking about situations like that, we have family members that come in and they're like, say, often it's usually the children that come in to visit us and say, well, what do we do about mom, or whatever, or dad? And if we get everybody around the table, despite whatever differences that they may have, if we can get them focused on what's important, which is how we're going to take care of dad, then they can leave their excess baggage outside the room. And so part of this then becomes for Mary is, okay, what can she do to, for one, what does she know about what's going on? Mm-hmm. You know, does she know what money that dad has? Does she know what money he is using to take, you know, so if the money is being used and, you know, for her father's care, then that's one thing. But if her brother says, well, you don't need to worry about this, you know, I'm in charge now, or, you know, you're a little sister and get out, or whatever it is, then to me that's an issue. It's potentially a legal issue, because if the son is like maybe not necessarily misdirecting or misappropriating the money, but if he's just like not doing good stuff.
Right.
I mean, because there are people that, okay, I'm trying my best, you know, but they don't know how to do this. You know, they don't know how to spend the money wisely. They don't know, you know, what. Okay, yeah, great. We can hire caregivers 24/7 or not. You know, but okay, what's your plan for taking care of dad? I mean, that's really what they need to, you know, have that conversation about.
And that is so important.
Yeah. And regrettably, here's Mary over here going, well, my father's in Alaska or Montana or wherever he is, you know, and she's going, you know, I'm not getting anything from my brother, and what I need, what information. And that's really what can be so difficult.
And as we talk about wills, estate planning, benefits, you know, should you set up a trust, all these things we're talking about now, how many family squabbles do you see? When is that a common thing? When you get to this stage in life, they're brothers, sisters, maybe, you know, they're focused on their parent, and they want to do what's right, or how much mistrust is there among siblings? And
you know, Ben, we don't see an awful lot of that. You know, and I know that there's a lot of it that goes on out there, because you know, needless to say, we get calls, you know, OpenLine and Morning Line and everything else, and you hear about stuff. But when people come into my office, you know, and they come into my office because they want to do it the right way. You know, I often say to people, I say, you know, when they come into my office and they say, well, we're worried about dad going to the nursing home, and they go, you know, we don't want all the money to go to the nursing home, that kind of thing. And it's like, that's okay. You know, that's good to be honest about. Asset protection, you know, is important to families, and it's important to our client. You know, and it may be important, like for instance, in Mary's father, is I'm worried that, you know, I don't want all my money to be used up for my care if there are other options. You know, he doesn't want to waste money, but at the same time, you know, if there are options are available to him to get care elsewhere. You know, so the squabbling families we don't see too much of, because people walk into our office and they pay us money, you know, to plan and to get it done the right way. Now, the other ones that maybe they come into our office and they don't pay us, and then they leave, and then they go squabble. You know, but most families, you know, when the time they get into our office, they want to do it the right way.
And so say, and then we'll go to break after this. But say you have a parent who is worried about their kids squabbling. Isn't that a great thing for that parent to do, to be very proactive, and to walk in and put a plan in place to prevent that kind of family discord?
Right.
And it can do that, right?
Yeah, they can. Yeah. And we can talk about that after the break if you like.
Yeah, why don't we talk about, because I know that's a big issue for a lot of people. What could could someone do, what could a parent do, an elderly person do, who, you know, knows, well, there could be some problems if I don't really lay things out with their family.
Right.
All right, so we'll take a break. If you want to call, there's a number, 615-737-PLUS, 615-737-7587. Wills, estate planning, benefits, whatever you want to talk about. We'll take a break, be back right after this.